Welcome to our latest Legal Insights video podcast. Today we're diving deep into collective redress for competition law violations. Our guest is James, a leading expert in competition law. James, let's start with a big question. Is it true that more eyes see more? How does this relate to competition law?
Thank you for having me, Emma. The phrase "more eyes see more" is indeed fitting when it comes to competition law. It touches upon the concept of collective redress, how multiple claimants can join forces to seek legal protection against competition law infringements. The recent judgment of the Court of Justice of the European Union in Case C 253/23 highlights the importance of providing a secure legal environment for such collective actions.
Interesting. But why is collective redress so crucial in competition law cases?
Many individuals and smaller businesses often feel powerless against dominant market players. They may lack the resources or legal knowledge to act alone. Collective redress allows them to pool resources, making it more feasible to challenge unfair market behavior, such as cartels or restrictive practices. The CJEU's judgment strengthens this right by emphasizing that member states, including Hungary, must ensure effective enforcement through collective mechanisms.
So, how does the European and Hungarian laws address this legal instrument? Are there clear paths for the harmed entities?
Absolutely. At the EU level, competition law ensures that the parties harmed can pursue their claims collectively. In Hungary, the Competition Act, TPVT, plays a main role in this question. It outlines competition law prohibitions and provides a framework for civil procedural actions. However, smaller entities often lack the resources large corporations have, making collective redress a critical tool for access to justice.
Let's get technical for a moment. What procedural tools does Hungarian law offer for collective actions?
Great question. The Code of Civil Procedure, PP, introduces the concept of co-litigators for procedural efficiency. This allows multiple claimants to sue together when their claims share a similar factual and legal basis. Essentially, it provides a structured path for collective litigation, which aligns with the CJEU's guidance in Case C 253/23.
It sounds like the recent CJEU ruling could have far-reaching effects. How significant is this decision for Hungary?
The ruling is indeed precedent-setting. The CJEU emphasized that collective redress is a valid and necessary mechanism for effective enforcement. In Hungary, this strengthens the enforcement of Chapter 2 prohibitions in the Competition Act, which may deter potential infringers by increasing the risk of collective lawsuits. Additionally, collective redress can improve the efficiency of the Hungarian Competition Authority, GVH, due to the fact that it can uncover multiple legal violations at once. Furthermore, collective redress is helping the judiciary system by consolidating claims and reducing administrative burdens.
Are there any downsides or risks associated with collective redress?
Like any legal mechanism, collective redress has pros and cons. On the positive side, it reduces litigation costs, lowers administrative burdens, and increases the chances of successful enforcement. However, creating a unified platform among multiple claimants can be time-consuming and complex. There's also the challenge of ensuring that all claimants' interests are adequately represented.
You mentioned earlier that more eyes see more. How does this idea play out in collective competition law cases?
The beauty of collective actions is that claimants can approach the legal problem from various perspectives. This synergy often leads to stronger, more comprehensive claims. Collective scrutiny makes it harder for infringing parties to conceal unfair practices, enhancing overall market transparency.
Finally, after this CJEU judgment, what do you foresee for the future of collective redress in Hungary from a competition law perspective?
The ruling opens new possibilities. It is a question for the future. that how the Hungarian legislation will incorporate the CJEU's guidance into domestic proceedings. While the co-litigators for procedural efficiency framework already exists, there may be further legislative developments to streamline collective redress procedures. In conclusion, the goal is to provide adequate legal ground for collective redress within competition law, because in case of any violations of the Competition Act, the harmed parties together should have the proper tool in civil procedure to enforce their rights in court, because more eyes see more.
Fascinating insights, James. Thank you for joining us and sharing your expertise on this important topic.
Thank you for having me. It's been a pleasure discussing such a timely and impactful subject.
And thank you to our viewers. For more updates and expert commentary on legal developments, don't forget to subscribe. See you next time.